Well, before I get started, let me also thank Matt and the ABA Criminal Justice Section for inviting me up to speak with you today. You can probably tell by my accent, I'm not from around here. I'm actually, as was mentioned in the bio intro, I'm from Forest Park, Georgia, where I've been for many years working with the U.S. Army Criminal Investigation Laboratory. But what I want to kind of touch on this morning is just a little bit about our experience with evaluating probabilistic genotyping results at our laboratory. And I think as Matt mentioned in the question that was asked, what practical considerations are there or out there that labs should consider when they move to it. So as Todd mentioned in his presentation, obviously there are a lot of different methods out there, and labs are kind of transitioning from CPI or CPE, which is a historical statistical approach, to a probabilistic genotyping approach. And some labs are validating, some labs are through validating. We were kind of ahead of the curve in that we started implementing a couple of years ago. So I just want to kind of share with you some of the lessons learned for us at our laboratory and our personal experiences, not only in putting the system online, but then also as we learned, as we started reporting results and then going and testifying to those results. So since I'm on camera, I want to go ahead and give my disclaimer first. What I'll be talking about is my own opinions and assertions, and I don't speak for my organization where I work, or certainly OSAC or SWGDAM, as was mentioned earlier, that I'm a part of. And this is a presentation I typically give to practitioners, so I know we've got a lot of lawyers and other folks in the room as well. So what I'm going to try to do is just kind of hit the highlights and kind of move through these slides for the sake of time as well. That way we can kind of open it up for questions from your group. But essentially what I want to touch on with this is, and this is very important for laboratories to consider as they move to probabilistic genotyping, is there's, as Todd mentioned, and even Matt mentioned at the beginning, probabilistic genotyping, there's a lot of different software tools out there to choose from, and they all calculate slightly different. So even if your laboratory says, hey, we're going to start reporting with probabilistic genotyping, you need to know that depending on the system you choose, you're going to get a slightly different likelihood ratio, depending on the model. In addition, two labs might choose the same software tool for probabilistic genotyping, and yet based on their protocol and how they interpret the results, they're also going to get slightly different answers. So it's important, I think, for the legal community as well to kind of understand that, is that they may have two labs using the same software tool, and yet why are they getting a different likelihood ratio result on the report? Well, it's, again, based on the protocol and how they validated that software tool and the particular features that they have chosen to use with that. So that's another important thing to consider, and I'll talk a little bit about these various methods for interpreting and reporting results and how that can relate to getting some different answers. In addition, and this is just not with probabilistic genotyping, this is a likelihood ratio model in general, and what we learned is that you set up different propositions, you're going to get different likelihood ratio calculations at the end, and that has to do with the propositions that you set up in both the numerator and the denominator, and a lot of that's based on the math itself. So I'll touch on that a little bit, and then talk about what can assist the court maybe in understanding the results, and that's there's pros and cons to it, but there's this idea of a verbal scale or a verbal predicate that might help with that. And then I want to finish up with some sort of admissibility and testimony strategies. And then I want to kind of open it up not only to my fellow panel members, but also to you guys to weigh in with any questions. So as I said, we were kind of one of the early labs, I guess, here in the U.S. to kind of go online with probabilistic genotyping. We've been online exclusively in our casework since November 2014. Our primary casework is sexual assault evidence. And at the current time, at least last I checked, we're trying to track this, is we've testified in 18 court-martials, general court-martials for the military now with probabilistic genotyping results. And of course, one thing we've learned is that the validation turned out to be the easy part. Interpreting and reporting the results has actually been the real challenge. As Todd mentioned, training your analysts in how to convey those results effectively at trial has been the real challenge for us. And it's not even the probabilistic genotyping part that's become the challenge. It's just with the likelihood ratio. So it just goes back to setting up those propositions and then explaining how that likelihood ratio works in contrast to our conventional way of giving statistical approaches, which is with CPE or CPI. So I think a very important point, if you don't get anything else from the talks this morning, is that as laboratories move toward this, training practitioners is going to be extremely important. So validation is certainly a big part of it, but equally, and I think very much equally important for laboratories, is getting your analysts trained up on how to not only use the software, but also to be able to go and testify to those results. So a big part of what we did in moving to probabilistic genotyping was training. Training was probably more extensive in terms of a timeline than it was at the actual validation part. And in addition to that, it's not just your lab practitioners that need to be trained up on the software. Your stakeholders need to be trained up on it as well. So one of the things we've tried to do at our laboratory is bring in, and we do this traditionally anyway, is to bring in not only our submitters, such as our agents in the field, to come in and get training on our results, but also we bring in both defense counsel and prosecutors to come in as well, so that we can kind of explain to them, especially when we transition to probabilistic genotyping and likelihood ratios, to get them to kind of understand how these results are going to be different and how they're going to be reported. So I think it's very important for laboratories to be engaged with their jurisdiction and their stakeholders, to kind of let them know as they move to probabilistic genotyping what these results mean. So I just want to give a couple of examples of some sort of considerations that we ran into, particularly with likelihood ratio results. So if you think about it, traditionally, DNA results, you usually get one of three conclusions, right? You either get an inclusion, an exclusion, or you get an inconclusive result. That's what the courts are used to hearing. That's the three basic outcomes of a DNA result. Probabilistic genotyping is based on probability. So it's actually set up a little bit different in the sense that you're no longer, or there is some school of thought to say that you no longer have to worry about an inclusion or an exclusion. Now you just sort of set up the likelihood ratio, you run it through your software, and then you're going to get sort of an answer at the end, a number, and then that number will sort of speak for itself on whether it supports the prosecution hypothesis, whether or the defense hypothesis, depending on how that proposition is set up. So that's in general how the likelihood ratio is set up. So as I say here, just some have advocated maybe no longer needing inclusion or exclusion, but instead just sort of let the likelihood ratio and the number that at the end kind of dictate what is being said. So that was a bit of a change for us, and something we had to look at when we were moving to probabilistic genotyping is, did we want to take that approach, or did we want to do some of the similar stuff that we had been doing, which was inclusions and exclusions. So there are, at least in my view, there are sort of pros and cons to each approach in doing that. So in other words, the two schools of thought would be run everything through the program and let the sort of the number speak for itself. And then the other school of thought is to still do sort of front-end interpretation, see if you can exclude the suspect or the person of interest up front beforehand, and if you can, then there's no need to even run it through the program and do a likelihood ratio. You just go to court and say, yeah, the individual was excluded from the profile. So the decision a laboratory sort of needs to make is which way they want to go. Do they want to include and exclude, or try to exclude up front before they run it through the program, or do they just want to run it through the program and let the number speak for that? So this just kind of shows what the pros and cons to that would be. Certainly the pros with running everything through is that it's considered by some to be less subjective, so the analysts aren't having to make those decisions with those complex mixtures to say whether or not an individual is included or excluded. Some would say, can you really include and exclude with complex mixtures? Some of the cons with this, though, is that if you start running everything through, as you guys know, there'll be some messy mixtures sometimes that you're trying to run through the program. And just like with any other software, it's kind of the junk in, junk out mentality. So if you certainly, even with any of these programs, if you run a junk mixture or messy mixture through, you're going to get a pretty junk output at the end. So you got to kind of make a decision, and this will be part of your validation as you go through to see, okay, what are your limits of your software tool with this? And the other negative is that if you start running everything through and the analyst isn't making any decisions as far as inclusions or exclusions, then when you go to court, you're kind of relying heavily on the software at that point, and then the question might be asked is, well, who's the real expert now? Is it the analyst on the stand, or is it the software itself that can't actually speak to the results, right? Because it's software. On the other side, if you interpret first, the pros to that would be certainly you can weed out some of these more difficult mixtures as being uninterpretable. That's some of the things that we've done at our laboratory through our validation. It's sort of that junk in, junk out scenario I mentioned, is to make some decisions up front, say, hey, it's not worth running it through the program to make any comparisons. So that goes back to our inconclusive that we've always reported. The analyst still serves as the expert for determining inclusions and exclusions. So again, if the examiner can exclude up front, that's what they're going to do. That's how they're going to report it out. They're not even going to run it through the software. Of course, the con with that, as I mentioned, is that there would be some subjectivity potentially with this in interpreting complex mixtures and making decisions up front. So I just wanted to present this slide to simply say laboratories, as they move to probabilistic genotyping, these are some of the decisions they're going to have to make and think about. The other thing is testing different hypotheses. So this goes back to the likelihood ratio model itself. There's assumptions that are considered for propositions. So number of contributors, for example, would be 1. Is it 2 contributors? Is it 3 contributors? Is it 4 contributors? And then also, what known contributors could you assume to be in the mixture? So if it's a vaginal swab from the victim as a sexual assault sample, for example, it might be reasonable and would be reasonable to assume the victim on her own vaginal swab, and then you could assume her profile, her genotype, in both the prosecution hypothesis and defense hypothesis. So depending on what assumptions you make for known contributors, that can also lead to a different likelihood ratio at the end. So you've got to be able to set these propositions, and as an analyst, you're going to need to do that to write your report. So one of the challenges you're going to have to think about is, well, we generally will know what the prosecution hypothesis is. If it's a sexual assault involving a victim and a suspect, generally if we get all the alleles are consistent with the victim and the suspect in the mixture profile, then the prosecution hypothesis we can pretty much predict will be that it's the victim and the suspect's alleles that are there. But for the defense hypothesis, we don't predict, and we shouldn't predict what the defense hypothesis may be, because it could change and it could be a lot of different scenarios. For example, it could be that the defense will concede that the victim's genotype is there, or they might say it's 2 unknown contributors. Those would be 2 different scenarios and could be 2 different propositions that you would run through the program, and then ultimately you will get 2 different LR calculations at the end. So what you have to consider at your laboratory as you're moving through this, since you don't necessarily know what the defense hypothesis is going to be, is to try and predict what's going to be most reasonable for both sides to include the defense, and then also what is going to be most informative for the court. And that's going to be for both the judge and the jury to make decisions. So I just wanted to give a quick example of what this might look like and something that evaluating 2 different propositions. So this is a sexual assault case where the evidence is semen on a vaginal swab from the victim. So the results are a mixture of 2 individuals with all the alleles consistent with the victim and the suspect. So again, we know the prosecution hypothesis is going to be the victim and the suspect. That's going to be in the numerator. In the denominator, the defense hypothesis, a couple different options here. The defense hypothesis would be that it's not the suspect, that it's an unknown individual that contributed the semen. So it could be a victim and an unknown, or again, if the defense decides they don't want to concede the victim, they could say it's 2 unknown individuals in the bottom. So what happens depending on how you set that proposition up is, well, if you set it up with 2 unknowns on the bottom, because you've got no unknowns on the top, then you're going to drive that LR way up. It's going to give an anti-conservative likelihood ratio calculation. That's just based on the math. On the other hand, if the defense does concede the victim, then you're going to actually cancel out those genotypes, and that's going to give a lower LR which is going to be sort of more reasonable for the defense to think about. The other thing, assuming the victim there, is that it reduces the different genotype combinations or the different genotype possibilities that may be there. So it sort of constrains to just the semen donor. So that also gives a more informative likelihood ratio as well. And so it's a combination of those two things, what's reasonable and then what's going to be informative. And that's how our analysts work when they write the reports. So conventional wisdom would be to try to minimize the ratio of unknowns to top to bottom because of the way the math works. And that's always something to think about as you're writing these propositions. In some cases, it's not going to be necessarily reasonable for the defense to concede a known contributor. And in that case, what we do is we would report out all the different propositions that are possible. That would be part of the report. Our analysts will go with what they feel is the most reasonable and most informative in the body of the report, and then we have a table at the end with the other propositions and what those other LR calculations were. So if the defense wants to talk about those, then we can certainly bring those up. Yeah, question in the back.
How does the analyst make that decision?
So that's where the training comes in. And so we had lots of different examples, lots of different scenarios that we looked at and worked with the group to say, okay, in this scenario, as a group, collectively, what do we think is going to be most reasonable and most informative? In most cases, as I said, if it's the vaginal swab from the victim, I mean, there's really not a big question to say that, you know, her profile's there and to go ahead and assume her top and bottom. Where it gets a little bit hairy, if you will, would be if you have multiple suspects or multiple victims and you want to see if you want to test them together in the mixture versus testing them separately, or you get neutral evidence, we call it, where it's you can't really assume, you know, any known contributor. So in that case, how do you rectify when you've got multiple knowns on top versus multiple unknowns on the bottom? So in those cases, what we just do is we have them all available in the report to talk about.
So the analyst meets with the prosecutor and develops a theory with the prosecutor and develops likelihood ratio based on that theory?
Correct. So we have a lot of pretrial, and that's one of the slides I'm going to get to is you're moving to probabilistic genotyping likelihood ratios. Pretrial conferences are going to be highly recommended, both with prosecution and defense, because we have the ability to do that in our courtroom settings, and it's very helpful because then the defense can kind of get a sense of all the different propositions, and then they kind of know, hey, the one they're gonna want to go with.
You don't find that problematic with the amount of subjectivity involved in interpreting low-level DNA?
As far as
cognitive bias issues, for example?
Well,
so you're getting a theory from the prosecution and you're using this to make an interpretation of the likelihood ratio. Given the subjectivity involved, you find that problematic?
We don't find it problematic at all. I mean, to me, it's not subjective. We are setting up, as I mentioned, what we feel is most reasonable and most informative, not only based on the proposition, maybe from the prosecutor, but also based on the data itself. That also plays into that in our protocol. So it's a combination of all of those. And again, if a laboratory is unsure what proposition to go with, the best answer might be to have them all in the report. And that way you get to court, and then at trial, the decision will be made which way to go. And it may be a situation where multiple propositions may be offered up to the court to consider, especially based on the complexity of the data. So this is just along the same lines of what I just mentioned. This is a verbal scale which can be somewhat, has been somewhat controversial, I guess, because, again, there's pros and cons to having it. One of the things we looked at our laboratory is oftentimes with these systems and with the likelihood ratio, you get this, you have multiple results you're reporting. So you can have one stain, crime scene stain where a person of interest is included, and you might get an LR that's 50 times more likely of them being there. And then the next paragraph you have, or finding, you have another stain where the person of interest is 50 septillion times more likely to be in the stain. So what do those numbers mean? Why are they so different? I mean, there's huge orders of magnitude we're talking about here. And how do we get kind of the court to understand that there are differences with those numbers and what they mean? So this is kind of where a verbal scale might be helpful or might assist the court with this. This is one that we've put together. It's using StarMix, which is a software tool that we use, and this just kind of gives you an idea of kind of how we could verbalize what these numbers might mean. So, for example, if it's 10 billion or greater, the likelihood ratio, we would say that's very strong support for the prosecution hypothesis over the defense hypothesis. and then the scale sort of goes down from there. This is somewhat arbitrary. There's no consensus right now in the community of what these scales need to look like. There's a lot of different ones out there. I think one of the things the community is working towards is trying to get more consensus with this, maybe have more of a universal scale that all labs can utilize. But this is one that we've used for a while now, and what we rely heavily on with this is our stakeholders. So we meet with our trial counsel and defense counsel, and this is for them. If they don't understand this and they don't accept this or think this is very good, then obviously we wouldn't use it, because we know what the numbers mean and we go with the numbers. So the reason I say this is to say, as a laboratory and as practitioners, as you move to probabilistic genotyping or likelihood ratios, that's one of the first things you need to do if you're going to implement a verbal scale, is to kind of get with your stakeholders to see, okay, does this verbal scale make sense to you or not, and is this helpful to you or not? I want to end just on a couple of papers, and then I'm going to open it up to our panel. This idea of an uninformative result. So what I mentioned here is, my pointer's working, but I'll walk over here. So when we get an LRs of 1 to 10, very low LR, we would call that uninformative. And what do we mean by uninformative? But by uninformative, what we mean is that the likelihood that, more likely that the person of interest being considered in this mixture versus a random man being included in this mixture becomes very, the uncertainty there becomes very close together as far as what's more likely. So in those scenarios, we would just report that out as uninformative for that individual being in there. The reason I bring this up is to simply say that there's a paper out, Forensic Science Genetics, you guys may be familiar with it, that Duncan Taylor wrote, that talked a little bit about this, where they actually did some experiments at the laboratory with low-level DNA and mixtures to see how the behavior of the likelihood ratio based on putting in known contributors and known non-contributors. And what they found is that as you get low level, as the complexity of the mixture gets more and more, and you get messier mixtures, I would say, the likelihood ratio starts to center around 1, which, as I mentioned at one of the beginning slides, is considered inconclusive for support for one side versus another. So we kind of utilize and reference this paper in our own work and with our own validation to kind of say they're along the same lines, is that once the likelihood ratio starts to approach 1, it really does provide more of an uninformative result. It's not that the software can't provide the result, it can still perform, it's just what it's giving you is a sort of an uninformative likelihood ratio at the end. So in terms of admissibility in courtroom testimony and just some of our strategies for this, another paper that's out there in Forensic Science, FSI Genetics, talks about this SEP, or software expert pair. And I think it's very useful, something, again, we reference, to kind of talk more about, when you're admitting testimony and you as an analyst are going to go testify for court, that you're utilizing not just the software, but that you as the analyst know how the software works. So there's, from the author's point of view, just from an admissibility standpoint in introducing probabilistic genotyping, there's, of course, ISFG recommendations out there, swig-down validation guidelines to help labs defend the work that was done in their validation. And then, of course, OSAC is also currently writing validation standards as well for these systems. Peer-reviewed papers for the particular software that where you got the results that you're testifying to are also critical. And the concepts of likelihood ratio, MCMC, modeling stutter, these are all terms and variables that and how these software tools function. These are not novel. These are all well published and well characterized in the literature. It's just important for labs to be able to reference those, especially as they get their first few testimonies under their belt in introducing these results. And so I think it's just important with this software expert pair with this, is that, as I mentioned at the beginning, it's not just training your analysts on necessarily how to push a button or how to work the software, but more importantly, it's how to explain the outputs and testify to the results that's equally important. And that's kind of what the paper gets to with this software expert pair. So in summary, there's lots of systems out there. They're all slightly different. Individual laboratory protocols may use the same system differently. Make sure you read and reference the literature to better understand the fundamental concepts. Training your staff is critical. You also need to understand the LR framework, particularly the proposition setting, because that's going to be extremely important, as I mentioned. Finally, these are not black boxes. These are not expert systems. Analysts, laboratories, practitioners, the legal community need to understand that as well. Don't treat it as a black box. You need to fully understand what it's doing. And finally, work with your customers and stakeholders as they need to be trained as well.
Comments from the panel?
Just a couple quick things. Thank you, Joel, for reminding me. I did not put up my disclaimer. Obviously, anything I just said or may say today is my opinion, not Swig Dams, not OSAC, not ATF. Two, that was not a paid endorsement for Gaithersburg. That's just. But more importantly, you were talking about subjectivity and bias, cognitive bias. I think it's important to point out that the interpretation and the statistical calculation are two very different steps. In our lab, and I think in most labs, you can do the interpretation before you ever know anything about, developing your hypotheses and things like that. You don't look at the reference sample. We completely interpret and document our interpretation of the evidence samples before we ever run the reference samples. The reference sample is done in a separate lab, completely separate time frame. So doing that interpretation and documenting that interpretation, what loci are going to be used, and even with these probabilistic software packages, you can do the deconvolution in the software before you ever develop the hypotheses and things like that. So you can do your interpretation, do your deconvolution, and then you can meet with the interested parties and start developing your hypotheses and things like that. But that takes a lot of the bias out of it that way.
That's a good point.
And I'll close the loop in just 1 second, and then we'll take your question. So I'm also work for the government, work for the for NIST, and so I guess we can say that between the Department of Defense, Department of Justice, and Department of Commerce, we're from the government, and we're here to help you. So, but yes, you had a question.
I guess particularly for Mr. Sutton, based on the talk that you just gave, but it seems to me that that entire talk is based on the assumption that the laboratories are working with both the prosecution and the defense. So if the laboratories are not working with the defense attorneys, then that whole thing kind of goes out the window, presumably. So is it your experience, because it's not mine, that laboratories work with defense attorneys?
No, that's not my experience at all. That presentation was hopefully to emphasize how critically important that is.
And so in using that, if, for example, if the laboratory was going to use it, would it be the recommendation then that they open up and work with defense attorneys and prosecutors?
Absolutely. And so that's when I mentioned at the beginning that this talk was given to practitioners in the past, and whenever we go talk with labs and share our experiences, we always emphasize that point. Yep. Question?
You said that it's not a black box. The defense bar always says it's a black box. Can you give us the reasons why you say it's not a black box?
Well, like I said, I don't have experience with all the different software tools that are out there. I just know the StarMix tool, for example, the one we use. The reason I can say we don't treat it as a black box necessarily is because I feel like we have spent many, many months opening that box up. Basically, kind of like taking an engine apart when you take it out of a new car and trying to put it back together. Part of that is really working with the developers too. Some developers are more willing than others to talk about the black box, for example, and explain what is inside it and how it works and all the underlying functions to it, whereas some may not. But that's another important consideration labs have to make when they choose a particular software tool is what do they want? Do they want a black box, something that they don't know much about and they can't get much information on, or do they want to choose something that they can go out, whether it's in the literature or somewhere where that information is there? And a big part of the training is taking that black box apart and figuring out what it's doing.
Other questions? Yes, sir.
Do you think that state and local laboratories would take the time to take this software apart, this black box, so to speak, in the manner that your laboratory is distinguished or full of, supported laboratories by the federal government? The state and local laboratories will take the time and effort to do what you
Yeah, I mean, I can't answer for the laboratories, but I sure hope so. I mean, I realize there are challenges with resources and manpower, and we've got caseloads and everything, but this is such a, as Todd, I think, mentioned, I mean, it is a huge jump moving into probabilistic genotyping and using software like this than what laboratories are used to. So they really do need to take the time to really understand, validate, and get to understand what, take it apart, as you say. I mean, I don't, like I said, I can't speak for the laboratories and what they end up ultimately doing, but I sure hope they do.
So Joel, would you say that if you had a lab that wasn't willing to put in that kind of work on the front end, that maybe they might want to reconsider whether or not now is the time to go into probabilistic genotyping?
Yeah, well, I think Todd alluded to it earlier. I think there are other models out there. They're all, if properly validated and used, I mean, they're certainly appropriate. So yes, I would say if they're not ready to put the work and put the effort into it, maybe going with these other more simplified models. I hate to say it quite that way, but to use these other models that aren't quite as challenging to implement would certainly be a good strategy.
Well, there's different ways of taking apart the black box and different levels of that. And some of the early labs going into it have really done a great job of getting into the details. And just, again, speak from StarMix, there's an extended output that will show you all the calculations that were made going through there. You can take that and go step by step, and you can try to redo those calculations by hand to show that it's doing what it says it's doing. All those formulas that are used in the software are published, all the models are published. So you can go through and you can recalculate all these things if you want to. Now, it's kind of a reiterative process, so you don't have to keep doing it over and over again. But if you've shown that it is doing what it's saying it's doing, then that's great. And I'm not, at some point that becomes reinventing the wheel. Does every lab have to go into the software and do the exact same calculations to show that it's doing what it says it's doing? Or can a couple labs do it early on during the validation, say, okay, you know what? These labs have done this. They've gone through this step-by-step process. They've shown us, it's following the formulas that it says it has in there. It's doing the stuff. They don't need to do that part, but you should still go through and just understand what's going on with this, would kind of be my opinion.
Yes, sir.
You talked about how you're letting, what you want to be able to do, and you're suggesting, in fact, the lab should be set up basically to work with the defense and the prosecution. In reality, like a lot of states, it's no. The DNA lab only work with the prosecution. Is that maybe, because the military criminal justice system is different. One day I'm a prosecutor, the next day the prosecutor is the defense attorney, and the defense attorney is the prosecutor. So is that somewhat a problem or your testimony is based upon it? You look at a different system than 99% of the people here. And that's...
Yeah, it's a very good point. Very good point.
Well, I would say, when we first get evidence in, we're not working for anybody other than the ATF. We're trying to find, get the results from the evidence. It's not for the prosecution. Usually there's not even an attorney involved, and there's no suspects involved, so the attorneys aren't even involved yet. We're getting the evidence in, we perform our analysis, we document our interpretation, and after that, it can go either way.
Yeah, well, in New York, we have a system where the OCME doesn't want to turn over any raw data on anything. They don't want to tell us how the software works. And then they say they're not really working for the prosecution. The prosecution is who gives them everything, and they give everything to. And judges in Queens say, oh, no, you have the report, you have everything you need, you don't need the raw data. You'll quash any subpoena to get it, any discovery of the raw data. I guess my question is, what would you say to a judge, your defense lawyer, about what an expert could do for a defendant with the raw data and software that goes beyond the report? Why do we need, as an expert, that raw data and software?
In my opinion, I think the data should be available to everybody. They can go back and run their own analysis on it. There's plenty of defense labs out there, defense experts out there, or experts in general, not defense experts, but just experts in general that are out there that can take that data and run it themselves, and you get whatever result you want. There's been several examples where different probabilistic genotyping software has been run on the same data and basically come to the same result. So, in my opinion, it should be shared with both sides. The raw data, I'm not going into taking the actual data that the output from, say, StarMix, which is a terabyte of data. Is anybody going to really do anything with that? But the electropherogram, the data coming off the instrument, I don't see a problem turning that over.
So Todd, going back to this issue of the prosecution and defense working with the lab, ATF, you're working with the defense, or you have the U.S. Attorney's offices, you have the defense bar out there. Do you work or attempt to work with the defense bar in coming up with propositions?
Well, we're still doing random match, so that's one of the bonuses. That's one of the hesitations for the community to move towards likelihood ratios, is because you do have to start making assumptions. You start to have to, working on both sides of it. If you do CPI, random match, you just do your statistic, and it doesn't matter what the hypotheses are. There is no trying to figure out what each side is thinking. But we are moving towards star mix, and that's something we're going to have to kind of overcome.
Just to add to that, I mean, because when we get a case in, just as Todd said, we work exactly the same way. We work the evidence, we set up our own propositions. We don't call the prosecutor or call the defense to get the propositions up front before we report them out. As I said, our analysts, based on the scenarios, based on the data, go with what they feel as the expert is the most reasonable assumption, the most informative assumption informative proposition and reasonable proposition for both sides. When we get to court, especially with these scenarios that may have multiple propositions being reasonable, is that we have those available that we can talk about at trial if need be. And so one of the things we try to do in terms of meeting with trial counsel and defense is to try to set things up pre-trial. And I think, as you mentioned, the court-martial system is a lot different than civilian world as far as being able to do some of that. But whatever a laboratory can do, I just feel like, whether it's how those meetings work or how the training works, I think it is important for any laboratory, especially with likelihood ratios, is to work with both sides to kind of to let them know kind of what you're going to be reporting and what you're going to be talking about.
So, and one thing I wanted to point out is that I think we're still quite early in the process of implementing probabilistic genotyping. I know there's several labs that have come online just in the last year, especially with star mix, but I think of just a ad hoc survey of the 230 or so crime labs, federal, state, local. There's probably close to about 100 that have either bought a probabilistic software program or in the midst of validating or have implemented a program. But we're still kind of early in this process, and it depends also, getting back to the question about the defense access, depending upon the particular program, the vendor, some vendors are much more willing to give defense access and training, and say, like, I know, for example, StarMix will give the defense a 2-month license that they could use the program to run the same data, if you will. Other vendors are not quite that way, so it just depends on the type of program, but that shouldn't prohibit the ability for the defense to use a different probabilistic program, because again, these programs use different models and different assumptions, and so it would be quite possible that, as Joel and Todd have said, that you could get different results, maybe not huge, but it's possible that you could do that, and then it becomes an issue of describing and explaining how you get these different results.
Just really quick, I know there's some push to have the DNA people work in a vacuum, have absolutely no information about a case. And, typically if there's no suspect involved in a case, we are working potentially with the U.S. Attorney if it's going down a certain line, or we're working with the agents, and they do give us information about the case. And it's not to give us a cognitive bias, but, if it's a case of an undercover buy where there's a gun that was found found in the suspect's home, but it was, we know it was handled by an undercover individual prior to that. It's good for us to know that. So if we have this mixture, as Joel said, the more unknowns you put in that likelihood ratio, the less conservative that number is. If we know, okay, look, this undercover person handled the gun and handed it to an individual, we fully expect to find his DNA on that gun. So we should put that in the likelihood ratio. So there's some information we do need to get about the case. Now, that's not going to affect our interpretation. I mean, it still isn't going to change what loci we use and, during the deconvolution and things like that. So, it's a little bit of kind of give or take. And so when it comes down to certain points, we are going to need some of that information. But as for forming the hypotheses, that can come from either side. And a lot of times, it's not, especially in our laboratory, there's a gun found in someone's home, or there's a Molotov cocktail, and we get DNA off the bottle of the Molotov cocktail. There's not a lot of different options for those hypotheses. I mean, a lot of them, I'm assuming 90% of the time, 95% of the time, they're going to be pretty straightforward hypotheses. If it gets more complicated than that, then we can work with whoever.
Yes, sir.
To what extent do the validation studies include blind testing? Where you feed it a known mixture, but the guy running the test doesn't know what it is.
So that gets to competency testing, I think, is kind of what you're maybe alluding to in terms of a validation design, because to try to answer your question, if I understand it correctly, what we did at our laboratories, once we completed validation, as part of the training requirements, is we had our analysts go through a competency test, if you will, which is what we would consider blind, because they didn't know what the answers were, where they were given a case scenarios, and then they were actually running it through the program, getting the results, and then reporting those out. And that's how those were reviewed and graded. Is that kind of what you're getting at? Worked out fine.
You're from the government, we trust you.
I mean, competency testing is not new. I mean, that's something, hopefully, laboratories that train their analysts on any new methodology or technology are going through. That's a requirement from quality assurance standards anyway. So it wasn't anything new for our group to have to go through that.
John?
Are there any regulatory bodies or regulatory organizations that decide which of these vendors' systems can be implemented in the United States?
Not that I'm aware of. I'm not. Question in the back.
Yes, sir.
Yeah. To the issue of what happens when you go from S plus B to U, S plus U to, or B. What happens when you add an extra U in the denominator, U plus U versus V plus U? That the arithmetic just rockets the whole thing up orders of magnitude. The likelihood ratio, to my ignorant eye, looks like the middle of the Bayes theorem. And it seems that you're reporting these things as if they were posterior odds, without having had the benefit of figuring out some kind of prior odds. And I know prior odds are a problem because people hate the idea intellectually of taking 50-50. For some reason, math folks hate that. And it's really hard to figure any set of prior odds without an enormous amount of data. But you guys have an enormous amount of data. So have you tried in formulating the hypotheses to kind of put those in the form of Bayesian prior odds and then do the arithmetic sort of going full frontal Bayesian? Would that ameliorate this issue of the different U's on the denominator?
That happens every single day in paternity testing, where you can have a prior odds that you then multiply times your likelihood ratio, your evidence, to get a posterior probability. But that is not yet in the sort of criminal casework mixture type evidence that we're doing at the moment.
Because?
Well, I think there's some hesitation. I know that in the UK, Ian Evatt tried this once, to have the jury to take out a piece of paper and a pencil and write down what you think is the prior probability of, this individual on trial, and then, now let's multiply that times the likelihood ratio, and I think it was pretty much quashed by the judicial system there. So I think there's a lot of hesitation in trying that in the U.S.
Well, do not try this at home, but which is what he was doing. I've been watching this stuff for a couple of 3 decades as they started with pure Bayesian, and they just totally pulled back, trying to slip through the middle third of it. But the problem with that's all fine, but the problem is the report comes out as if it were a posterior odds, without the benefit of multiplication.
Well, there has to be a lot of really careful consideration of how you state the likelihood ratio, that you don't commit the so-called fallacies of transposing the conditional to where you're not talking about the evidence based upon the hypotheses of either the prosecution or defense, but you switch it to where you're talking about, here's the theory of the case from the prosecution, and the evidence confirms that. So you have to be very careful in the way that the likelihood ratio is presented. And there have been several court cases in the U.S. where the expert has transposed the condition, and they've gone, I think, all the way up to the Supreme Court. So it's a very different way to present evidence, but I think that it's important because, as Todd and Joel mentioned earlier, I mean, why should we even change? Why not just stick with what we're doing with CPI and RMP? And I think that there are a couple of things that happened that really has changed our entire thought on DNA evidence. Is that there was a study by the NIJ back in the mid-2000s or so that showed that you can get a lot of information from so-called property crimes where you may have sort of touch evidence, steering wheels and handguns and things, and show that there could be real benefits. You may be able to find someone, maybe early in their criminal career and so forth. That led to a lot of submission of those types of cases, which became very overwhelming to labs. In addition, we've had a fundamental change in the type of STR kits that we're using. The kits now have different chemistries, different enzymes that are being used, different fluorescent dyes, the actual instrumentation, the lasers are different. So we're getting much more sensitivity now, and we're picking up a lot of profiles that we would never have seen 15 years ago when we were running these cases. And so that has led to then a change in the CPI, using the CPI, because there have been several studies, one in particular, John Buckleton and James Curran. They did a simulation where they created a bunch of two-person mixtures. These are just artificial creations of two-person mixtures. And then they created a third person that was independent. And they did a comparison. Could you fit, if you will, fit that third person into the two-person mixture that was created? And they found about 50% of the time you could give a CPI that would say we could include 95% of the population with someone who's a non-contributor. And so that's the real risk of using CPI when you have low-level data with dropout. Back in the early days, as Todd mentioned, historically, when crime labs were mostly processing sexual assault or, blood, blood on a knife that's a single source, there was really no issues when you had lots of DNA and there was very little chance of dropout. It's when the sensitivity started to increase and the types of cases where dropout is a potential is where CPI becomes a real problem.
What was the study again?
This was a study by John Buckleton and James Curran in the Journal of Forensic Sciences. And I can't remember the exact name of the paper at the moment, but I could send you the reference if you would like.
Yes.
Yes, sir.
Is there any problem, when you talk about a mixture and a likelihood ratio, and you probably get the comparison from people you want to get a comparison from to get the ratio, when the three, let's say the three people that you want to know, is it more likely than they were three people, whatever, or like, let's say brothers with the same mother, same father, would that affect the likelihood ratio and the use of the likelihood ratio in a mixture? Or
There are ways that you can calculate the likelihood ratio if you consider that there are relatives involved. So it's quite possible to consider that possibility that you may have brothers or father and a son or whatever in the mixture. So you could calculate a likelihood ratio considering relatives.
well, would it affect the ratio? Let's say Peter next to me and I do a comparison, we're not related or anything we know of. But when you have a brother, father, and son, would it affect the ratio at all, make it less reliable?
Well, I don't know if I would say less reliable. It would give you a probability that would give you a a statistic that would either favor or not favor that you were related. And so compared to someone who is unrelated, again, it depends on the evidence. It may be a lower likelihood ratio compared to unrelated individuals if you actually were related. So that's the kind of case information that would be useful in doing the likelihood ratio. And again, that's where discussions with both the prosecution and defense would be helpful in that aspect, where it would be difficult to try to do that calculation on the stand. And when it's brought up, well, what if they were brothers? You know, that kind of calculation would take some doing. So it would be useful to have that information before.
And correct me if I'm wrong, though, I mean, it may not have any effect if the prosecution's hypothesis is suspect, the numerators, you would see this evidence, probability of seeing this evidence if suspect 1 and suspect 2 were the sources. It doesn't matter if they're brother and sister, its probability is still going to be 1. And then the denominator, the other hypothesis would be it's 2 unknown, unrelated individuals. Then it doesn't have any effect. So again, it really depends on the question that is being asked and what you're trying to do the calculation for.
Other questions? John?
Have people given any thought to the proposition that DNA, which used to be the gold standard and now is not so much, part of that problem is trying too hard and trying to lower the sensitivity beyond what we currently are capable of handling?
Yes. I think, it's this pendulum, and this, again, my opinion, the pendulum's kind of swung from, hey, let's see exactly how much, let's get as much as we can from the stuff. I mean, you see these ancient DNA people that are getting, DNA from bones from 2,000 years ago, the whole Jurassic Park thing. And it's like, wow, we can do that. We can get DNA from half a cell. What good is that? Because there's just as good a chance it's going to come from me or something in the plasmid, the reagents, things like that. So now I think the pendulum's swinging back and people are saying, yeah, maybe we don't want to go quite that low. There's too many issues that are involved with that.
But I do think, as far as DNA being the gold standard, if it's a single source, blood, then there's no issues. I mean, that's been well accepted for a very long time. There's population genetic models that are used not just by forensic scientists, but other scientists in the field. It's the mixture problem that's really an issue. And I know John Butler has advocated, and others has advocated using something called a complexity threshold, where you make the decision, we're not going to touch this mixture because it's just too complicated and too complex. Now, certain people or different labs will have different ideas on where that threshold is, but certainly you could spend a lot of time and a lot of effort running that messy, as Joel said, that messy mixture through your probabilistic genotyping software, and you end up with basically an uninformative likelihood ratio.
So Mike, as forensic laboratories move toward implementation of these new statistical approaches for interpreting mixtures, are we approaching a time where we should or need to go back and review old and maybe not so old cases where less informative approaches might have been used?
Well, I think it certainly depends. I mean, I think if the laboratory had, if the laboratory was using the CPI appropriately and using scientifically valid reasons. So, for example, if they are using a stochastic threshold and they are considering that potential dropout is an issue, and they are doing CPI that way, then there's nothing wrong with the statistic that was generated. The problem is if you're not considering dropout and you're just simply anything goes. And so this is what happened in Texas. If you're not familiar with what happened in Texas, and this is all public knowledge, but basically the Texas DPS labs did not implement a stochastic threshold until 2015. And so any casework that was done prior to that, it was pretty much anything goes. Any peak that was there would be used, any peak that was above the analytical threshold. So And so there was this case where there was this, I think it was a screwdriver or some tool that had blood evidence on it, and the report was 1 in a billion. The statistic was, CPI 1 in a billion or something to that effect. And so then in 2015, they implemented a stochastic threshold, and so the prosecutor said, well, I'm getting ready to go to trial. Could you recalculate the statistic? Because at this time, the FBI had come out with their correction in the allele frequency data that had been used. They found some errors in the original data that was generated for the allele frequency. So he said, could you please recalculate? And so they said, well, yes, but since this is a new report, we're going to have to use our new protocol. And the statistic went from 1 in a billion to 1 in 100, because now they had to throw away a lot of the data because it was now below stochastic. Now, I just talked a few weeks ago. I was here in New York for the DNA subcommittee meeting, and I talked with Brian Gestring, and he said that he was at the ASCLD meeting, and he talked to someone, and they said they just reanalyzed that case with StarMix, and they got something like 1 in a quadrillion now. So it just goes to show, depending upon the model that you're using, you can get different results from the same evidence because you're making different assumptions or you're using different models. So I think as far as historically, should we go back and look at all of the old cases that were done prior to, the probabilistic genotyping? I think it just depends. If you're doing it correctly, I don't think there's an issue. If like in Texas, if they realized that they weren't doing everything with a stochastic threshold, then I think they did it the right way. They got both the prosecution and the defense in the room and said, how are we going to move forward with this? And they have become, I think, a real model for the way that it should be done. I know that Virginia has gone back and looked at previous cases when they brought True Allele online. And so it just depends, and I think a lot of it depends upon the lab and the communication between both parties, all parties involved.
Victor?
So all of this discussion has been using traditional DNA testing technologies. As we move to massive parallel sequencing, do you anticipate a whole new statistics?
Well, I mean, what little we've looked into it just at our laboratory, and we have been looking at massive parallel sequencing a little bit at our lab, is yes, I mean, I think we still feel like probabilistic genotyping will still be sort of a statistical model that we'll use for that. I know there's still a lot of developmental work that has to be done, but yeah, I mean, it's a good question, and certainly as we move towards that, that will certainly be something we'll have to consider.
We're working on, in the beginning stages of a project right now, we're trying to see if the probabilistic genotyping software we were planning on implementing will be able to use the same data that comes off of next-gen sequencing. Instead of RFUs, it's going to be read counts. We just want to make sure that translates well with this stuff. So I think it, that's obviously the hope, but I think the whole process is still fairly early on. And if we go from using, 13 STRs to 1,000, that may be a whole different issue anyways.
My sort of thought is I think that, there may be some discoveries that are made in this examination of next-gen sequencing that SNPs may actually be a nice marker system for mixtures and so forth. So we may or may not be using the same sort of statistical. I think the likelihood ratio is still probably the way to go. But yeah, I think there's a lot of data to be mined in the future.
I think this is like any jump in technology. In 91, 92, when we were doing serology, we were doing ABO typing on blood stains. We were doing PGM, Pepe. They had the starch wars and stuff back then. But I mean, discrimination values were, if we had 1 in 10, prosecutors were just, thrilled with that. And then we brought on DQ alpha. So we brought on our first DNA typing method, which was 1 in 25, but we could do, smaller stains. we had that same question of, hey, should we go back and do these old cases where we were only doing ABO typing and results were inconclusive or they at low level? Then we brought on polymarker, and that was another kind of jump. Then we brought on D1S80, and then we brought on PowerPlex. So, I mean, it's with every generational step of this technology, there's always that question, what do we go back to? How do we go back to it? How do we make that decision? If it's, the jump in the statistical approach versus the actual lab science we're doing, it's, either way, there's always that question, what do we go back to? How do you make that decision to go back to it?
And are we going to be able to use it with, or to apply new approaches to some of the earlier technologies or methodologies?
Yeah, it's going to be a real challenge, yep.
But we want to keep that gold standard.
So who should be responsible, Mike, for establishing these scientific best practices for DNA mixture interpretations?
Well, presently, SWGDAM is for at least for the U.S. has that mission, I guess, to develop guidelines. I know that there's a lot of limits. Again, not to pick on Texas, but they didn't implement a stochastic threshold until 2015, but that was one of the recommended guidelines in the 2010 SWGDAM guidelines for interpreting autosomal STRs. And because they're guidelines, that doesn't necessarily mean that they're things that you could be audited to. And so what's really needed are more standards. And I mean, the current standard, one of the current standards for mixtures in the QAS guidelines is, do you have a mixture protocol? Yes or no. It doesn't say anything about the type of protocol you have, the quality of the protocol. It just simply asks the question, do you have one? And so developing more standards, I think, would be quite beneficial. So then that way labs could be held to a standard. The OSACs are in the midst of developing some mixture interpretation SOPs, or at least standards that could be used for labs. And so we have a task group that's working on that. Joel is a part of that, I think. So those will be things that will be coming eventually, but that's, I think, what's really needed. I know that in talks that John Butler and I have had with ASCLD Lab that, there's don't give us guidelines, we need standards.
And do you think that that's going to be something that is going to be the focus of the OSACs?
Yes, so the OSACs are definitely working on standards and guidelines to have more of a consensus and, again, potentially be enforced through the accreditation agencies and so forth. And I know that SWGDAM is doing a lot of work. I think that, not to be too biased, but Joel and I were part of the group that worked on the SWGDAM guidelines for validating probabilistic genotyping software, and I think there are a lot of really good recommendations in there for things that you can do. Like the question is, what if you have a non-contributor? That's one of the tests that we suggest that you should run. So get an answer from your mixture and then take, several hundred people that are not in a mixture and see what kind of stat you get, and that will help inform you where you may find the limits of your particular type of mixture. So I think there's a lot of good information in those guidelines, but I think that moving forward, we need to have more standards in operation.
Yeah, I think laboratories want that. I think they're asking for it, and I think that's where the community's moving. So I think we are moving in that right direction.
Other comments from the audience or questions? We're finished a little early, but let's take about 20 minutes then. But first, let's thank our panelists.